A very good morning, dear friends. Today we are going to deal with the definition of contract and the ingredients of contract. Now, as you know, in India, the law with regard to contract is based upon the Indian Contract Act 1872. But even though there is a specific statute dealing with contract in India, we have based our principles of contract on the English law of contracts. Hence, the laws with regard to contract, which is applicable in England, is relevant even now in Indian law. First of all, we will start with the definition of contract. For that, we have to analyze the concerning sections under the Indian Contract Act. Now, most of the definitions are given in Section 2 of the Indian Contract Act. So, what is a contract? Now, contract is, if you go for Malayalam, ഒരു കോൺട്രാക്ട് എന്ന് പറഞ്ഞാൽ നമ്മൾ ഉടമ്പടി എന്ന് പറയും. Now, what is a contract or what is an ഉടമ്പടി? In that sense, a contract is defined in Section 2 of the Indian Contract Act as an agreement enforceable by law. So, what is that? A contract is an agreement enforceable by law. Now, the question is here, what is an agreement? We generally know what an agreement is, but we have to give a legal definition to it. Now, in the Contract Act, the term agreement is also defined. So, we start with what is a contract? A contract is termed as legally enforceable agreement. Now, the question is, what exactly is the relevance of the term legally enforceable? It has its own relevance. What is it? Now, you can make agreements and agreements, 100 types of agreement. But all agreements are not contract. So, every day you can have so many agreements. For example, my son asked me, or my daughter asked me, evening, you get me 2 pens. Or father, in the evening, you get me 2 churidar. And I say, okay, I'll get you 1. So, this is also an agreement. Now, the question is whether it is legally enforceable. Can she sue me if I am not getting the pen, or can she sue me for not getting the churidar? That is the question. So, the thing is that you can have agreements of different nature, but all agreements are not enforceable. Then what is enforceable? If an agreement is enforceable, then it becomes a contract. So that is the distinguishing factor. So there is an agreement, and the enforceability creates or makes it into a contract. We go for some examples where there are agreements which are not enforceable. For example, I enter into a contract with a terrorist, asking him to put a bomb in the Aegis office building at Trivandrum. It so happens that, out of mistake, instead of bombing the Aegis office building, he bombs the Peerlessly or Coders building which is near it. I've given him an advance of 10 lakhs and I have to give him back another 95 lakhs. Now, in this situation, that is, I've given him money to bomb one building, he bombs another building. So, here also there is an agreement. But can I move the court claiming that, dear court, get me the advance amount of 5 lakhs, or ask him to put the bomb in the real place? Can I file a case? It's not possible, because here also there is an agreement, but this agreement is not enforceable by law. So the first point is that a contract is an agreement enforceable by law. Now, Now comes the question of what is an agreement. Let's see what is an agreement. In the Indian Contract Act, an agreement is defined as a set of promises forming consideration to each other. An agreement is a set of promises forming consideration to each other. What does it mean? There is one promise, there is another promise. It creates a set of promises and both have consideration each other. I'll give an example. See, let's consider one of your name is Parvati, for the sake of it. Now, I enter into an agreement that I will buy Parvati's watch for a price of 5,000 rupees. Got it? And Parvati says, okay sir, I agree. So I'll buy Parvati's watch for 5,000 rupees and she will give me the watch for my 5,000 rupees. Here what is happening? Here there is one set of promises or two promises. One, my promise to give Parvati an amount of 5,000 rupees in consideration of the watch. And on the other hand, Parvati's promise to give me the watch in consideration of the 5,000 rupees. This is what is stated as a set of promises. And the set of promises is forming consideration to each other. And this set of promises forming consideration to each other creates an agreement. And an agreement enforceable by law. Obviously, it is a contract. So we have seen or defined the second term, an agreement. So we have seen a contract, legally enforceable agreement. Second, there is what is an agreement? A set of promises forming consideration to each other. Now, the next point which we have to decipher or understand is, the next term which we have to define is the word promise. We come from contract to agreement and then to promise. So we know what is a promise. We have the saying, promises are to be kept. Legally it is called pacta sunt servanda. But here, in the parlance of contract, the question is, what is a promise? Now, in Contract Act, the term promise is defined as, again it is defined in section 2C in sections of the Indian Contract Act. It is defined as a proposal when accepted by the person to whom it is made. I'll repeat once more, as there was a slip of tongue. A promise is a proposal when accepted by the person to whom it is made. It is called by the name a promise. So what is a promise? Again, when you make a proposal to one particular person, Parvati, will you sell me your watch for 5,000 rupees? This is the proposal I make. And Parvati says, okay sir, I am ready. That is a proposal when accepted by the person to whom it is made. I make a proposal to Parvati, she accepts it. That a proposal when accepted by the person to whom it is made, it is called by the name a promise. So that is a promise. What? A proposal accepted by the person to whom it is made. Here also there is one point to be noted, that a proposal can be accepted only by the person to whom it is made. I make a proposal to Parvati. Say, Parvati, I'll buy your watch for 5,000 rupees. Radhika, who is nearby, says that, sir, I'll give you two of my watches. I like you so much. But she can't accept it. A proposal can be made to anyone. But a proposal can be accepted only by the person to whom it is made. If I make a proposal to Parvati, it can be accepted only by Parvati. If you make a proposal to Radhika, it can be accepted only by Radhika. Incidentally, in case of marriage, usually you say that a proposal has come. When you propose to marry one particular person, they cannot accept it for her sister or her auntie or whoever it is. When I make a proposal to Ramani, it can be accepted only by Ramani, not by her elder sister or auntie or whoever it is. So that is the rule with regard to proposal, that proposal can be accepted only by the person to whom it is made. And when this proposal that is made is accepted by that person, it becomes a promise. So a proposal, when accepted by the person to whom it is made, it becomes a promise. And a set of promise forming consideration to each other becomes what? An agreement. And an agreement enforceable by law becomes a contract. Simple. Now, there is one more term which needs more clarification. That is proposal. The term proposal is the first definition which is given in the Indian Contract Act in section 2. It starts with 2A, proposal. And what is a proposal? It's somewhat confusing. You don't have to understand each and every point and word in that definition. You just have an overview or idea of what is a proposal. I'll repeat the definition of proposal. What is a proposal? When one person signifies to another person his willingness to do or abstain from doing a particular act with the assent of such person, then that is called by the name a proposal. What is that? When one person signifies to the another person his willingness to do or abstain from doing a particular act with the assent of such other person, then it is called by the name of proposal. That is, when I make a proposal to Parvati, Parvati, will you sell your watch to me for 5,000 rupees? I make a proposal. That is, when I signify to Parvati my willingness to do or abstain from doing a particular act, to give 5,000 rupees or not to give 5,000 rupees to any other person with the assent of such other person, with the assent of Parvati. And that particular activity is known by the name a proposal. Once more, proposal, when one person signifies to another person his willingness to do or abstain from doing a particular act with the assent of such other person. That is, depending upon what Parvati says. If Parvati says that I am ready to give the watch, okay. If Parvati says that I am not ready to give the watch, the proposal is not accepted. Whatever it is, this is proposal, when one person signifies to the other. So that is a proposal. Proposal, when accepted by Parvati or the person to whom it is made, it becomes a promise. A set of promises between Parvati and me with regard to 5,000 rupees and the watch. A set of promises forming consideration to each other is called by the name what? Agreement. And an agreement enforceable by law becomes a contract. So this is very simple. This is a contract. But you have to understand the definition properly. You have to follow the sections. You don't have to repeat it. It's all there in section 2. See, in the Contract Act, there is also another section dealing with definition of contract, a little more broader one. For the sake of it, I'll repeat it also, or I will explain it also. That is section 10 of the Contract Act deals with a definition, a broader definition of a contract. It goes like this. All agreements are contracts if they are made by parties competent to contract with consensus ad idem for a lawful consideration and lawful object and not expressly declared to be void. Repeat. All agreements are contract if they are made by parties competent to contract with consensus ad idem for a lawful consideration and lawful object and which are not expressly declared to be void. This definition covers almost all the aspects of a contract at the stage of a procedure. Notice it. All agreements are contract. Okay. Well, if it is made by parties competent to contract, so first essentiality of a contract is the competency of the parties. What is the competency? One is he should be a grown-up person. He should be a major in the legal parlance. Second, he should not be a unsound person. That is, he should not be an insane person. So such persons cannot enter into a contract. So obviously for so many reasons. Because they don't understand the nature of the contract. So the first point is that for a contract to be valid, the party should be competent to contract. See, the rule is that if suppose I see a 3-year-old boy, 3-year-old child, he is having a gold necklace. I go to him, say, Monu, we will have a contract with uncle. I will give you 2 Cadburys and in return you give me that bad bracelet or bad necklace. The boy will be willing. Later can I say that I had entered into contract with the Monu and got that bracelet or necklace? You can't do that because he is not in a position to understand the nature of the contract. That is why we say that for a valid contract, the party should be competent to contract. This part. Secondly, there should be consensus ad idem. Consensus ad idem means when 2 parties enter into a contract, they should have a consent. Consent in the sense that they should meet each other. There should be minds meeting each other. They should consent on one particular thing, not on 2 different things. For example, I say Parvati, I will buy that. She says, sir, you can take this. What I mentioned or what I referred to when I said that was her bag, and what she had in mind was her watch. See, there is a problem. There is no meeting of mind. It goes like this. For a contract, there should be consensus ad idem. Meeting of minds. The 2 contracting parties should agree together with regard to an object in uniformity. That is called consensus ad idem. So that is the second part of the definition. All agreements are contract if they are made by a parties competent to contract with consensus ad idem for a lawful consideration and lawful object. The object of a contract should be legal. You can't have illegal object. And the consideration, that is what you give for as the price of the promise, what you give in return, that should also be valid, legal, should not be immoral. For a consideration should be valid consideration. It should not be an immoral consideration. For example, an agreement with a call girl, a prostitute. There are agreements in it You come tomorrow to such and such a place, I'll give you such and such money. Essentially, it is an agreement. But you can't go to a court claiming that she had not come. Dear court, you make the arrangements to send her with me. It's just impossible, isn't it? Because the consideration here is immoral. And they are almost similar. The object of a contract also should be legal. That is, you can't have a object of a contract as bumping the edges of a building. So this covers almost all ingredients, basic ingredients of a contract. That is, all agreements are contract if they are made by parties competent to contract with consensus ad item for lawful consideration and lawful object, and which are not expressly declared to be void. That is another point which I have left. The meaning of that term is that if a contract is expressly declared to be void in the policy of a country or in a particular country, it is invalid. For example, in Kerala, you don't have a agreement to import or to buy arak, because the sale of arak is prohibited in Kerala. Similarly, if there is a state where alcohol is prohibited, you cannot have in that state agreement for buying alcohol. Or you take another sense in Kerala or some states, betting on the basis of horse, like they do in Ooty or something like that. Horse racing, that is banned. So you can't have an agreement over it. So these are some important points with regard to a contract. So first is, as we have said earlier, what is a contract? Is an agreement enforceable by law. An agreement is a set of promises forming consideration to each other. A promise is what a proposal accepted by the person to whom it is made. A proposal is when one person signifies to another person his willingness to do or abstain from doing a particular act. That's one part of the definition. The second part is all agreements are contract if they are made by parties competent to contract for a lawful consideration, lawful object, which are not expressly declared to be void, and there should be consensus at I hope you are having an overview of what is a contract. This is only the beginning of the contract. I'll be continuing on different parts of the contract later. So thank you very much. Thank you for patience.